switches out if you want.
Oh yeah, I forgot I was running the mic. I was asking about the introduction. I was probably advertising that to them.
Ready? Whenever you are, yeah, sure.
Good afternoon. I'm Kevin Vance, the Director of the Center for Constitutional Liberty. And let's see, our next event is Monday. There's a lunch talk with Dr. Meinert. So if you'd like to sign up for that, please let me know if you haven't already. And very excited about our speaker tonight for one of the biggest issues that our country is facing, especially this Supreme Court term. And I'm going to introduce one of our constitutional fellows who's going to introduce our speaker. Jude Healy is a sophomore from Branson, Missouri, and he's an honor student in addition to a constitutional fellow. He's an RA and interested, among other things, in environmental policy and law. So, Jude.
NCLA's president and chief legal officer, Mark Chenoweth, has observed the administrative state up close and personal from perches of all four branches of the federal government. Mark served as the first chief of staff to Congressman Mike Pompeo, as legal counsel to Commissioner Ann Northup at the U.S. Consumer Product Safety Commission, as an attorney advisor in the Office of Legal Policy at the U.S. Department of Justice, and a law clerk to the Honorable Danny J. Boggs on the U.S. Court of Appeals for the Sixth Circuit. Mark has worked in several different roles in the private sector as well. He began his legal career in D.C. as a regulatory associate at Wilmer, Cutler, and Pickering. He then returned home to his state of Kansas to serve as an in-house counsel for Koch Industries. Most recently, he has spent over 4 years as general counsel of the Washington Legal Foundation. Mark is a graduate of Yale College and the University of Chicago Law School, where he founded the Institute for Justice Clinic on Entrepreneurship and became a Tony Patino Fellow. Mark has been widely quoted and or published in newspapers and websites, including the New York Times, San Francisco Chronicle, the New Hampshire Union Leader, and Metropolitan Corporate Council. He has also had recurring op-eds in the Los Angeles Daily Journal and at Forbes.com. Please help me welcome Mark Chenoweth.
And a graduate of Olathe South High School. I don't have that in my bio, but for this crowd, do we have any Olathians in the crowd? Maybe one or two? Yeah. Okay. Fantastic. Okay. So I lived there for 18 years and loved growing up in Olathe. My dad was stationed at Fort Leavenworth for a while during the time I grew up, so I didn't make it to Atchison very often, but it made it to Leavenworth a whole lot, shopping at the PX and all that kind of thing. So I know this part of the state a little bit. We used to come up here to do some pheasant and quail hunting as well, which I assume that's still a good part of the state for quail and pheasant. Anyone? So got some hunters in the crowd? Okay. All right. I don't get to do that in D.C. I do a lot of hunting, but it's not hunting of birds. It's hunting of swamp creatures mostly. We are at the new Civil Liberties Alliance. We've only been around for about 6 years, and we were founded by Philip Hamburger, who is a professor of constitutional law at Columbia Law School in New York. And Philip wrote a book just about 10 years ago called "Is Administrative Law Unlawful?" And it's about a 700-page tome. He calls it his doorstop. But it's really a magisterial work of legal history. And what Philip did was go back and look at what was happening in the United States at the time of the founding and in the run-up to the founding, and shows that a lot of what is happening in the modern administrative state is very similar to what was happening under the monarchy. And that folks say, well, the Constitution didn't anticipate the administrative state. This has sort of grown up organically. There's nothing in the Constitution that prohibits it, that kind of thing. And Philip says, no, wait a minute. And it's not just the Declaration of Independence, but if you go and you look at the Declaration of Independence, there's a phrase in there that will jump out at you, where Thomas Jefferson talks about King George III sending officers to harass the people and eat out their substance right, and creating new offices to do this. Sounds a lot like the administrative state from my perspective. But there are aspects of what was happening back then. You had, right, the Star Chamber, you had, and this isn't all right before the founding, but this is in the couple hundred years leading up to the founding of our country. You had royal prerogative, where the king could overrule what the judges were doing, or he could say, well, the law applies to some people but not other people, or he could do things outside of the regular order. And so Philip walks through all of these things and shows how there are sort of modern counterparts to that in the modern administrative state. So what does that mean? It means that most of what's happening in the modern administrative state is unconstitutional. The Constitution was written precisely to prevent those things from happening. What we want to have is law that goes through regular process, right? That goes through bicameralism and presentment. The House votes on it, the Senate votes on it. If I told you it's the second most cited Supreme Court case in United States history? Any guesses as to what number one is? You can just shout it out if I hear it all. That's it. Marbury versus Madison's number one, Chevron's number two. So we're talking about an extremely important case that gets cited all of the time. And it's, I will oversimplify the holding of the case for our purposes, but essentially what Chevron says, it's called the Chevron two-step. The first step of Chevron is that you look at the statute and you see if what the statute says is clear, and if it is, then that's what you have to do. But if there's an ambiguity in the statute or a gap in the statute, then Chevron says that there's a presumption that Congress intended for the agency to fill the gap or resolve the ambiguity. Now, that presumption is a fiction. Congress has never said that that's the job of the agency. In fact, Congress wrote a law in 1946 called the Administrative Procedure Act. And the text of the Administrative Procedure Act says the opposite. It says that courts will have de novo review, which means de novo, right, new. It's without any deference to the agency, will review those decisions de novo. That has been ignored that statute has been ignored for the last 40 years by the Supreme Court. Not the entirety of the Administrative Procedure Act, but that little part that contradicts the Chevron deference. So why does it matter? What happens when Chevron is applied? Why should you care about it? Well, what it means is that if you're suing a federal agency, or a federal agency is suing you, then you actually don't get an independent judge. You might think that you do. You might think that the Constitution goes to a lot of trouble to ensure that federal judges are independent, right? Lifetime tenure. They can't reduce the salary. And if you spend some time going through, I think I have my copy of the Constitution on me, I usually do. If you go through the Constitution, you can find a dozen different ways in which the Founding Fathers tried to ensure the independence of the judiciary. I gave you the most obvious ones, But did you know that federal judges can't be members of Congress? Why is that? To ensure their independence from the legislative branch. Members of Congress can't serve in the executive branch. Same reason. Or excuse me, well, I mean, that's also true, but what I meant was to say is that federal judges can't serve in the executive branch. Same reason, to preserve that independence. Federal judges cannot be members of the Electoral College. Same reason. No religious tests for federal judges, right? There's all of these different ways that we went through in order to ensure that you would have an independent judiciary. So what good does that do us if instead of, when you get in front of a federal judge, instead of the judge taking a look at your interpretation of the statute and taking a look at the government's interpretation of the statute, an independent judge would do that and decide who has the better view of the statute, right? And the judge would say, well, you have the better view of the statute, therefore you prevail against the government. That's not what happens under Chevron. Under Chevron, the judge looks at the government's interpretation of the statute, decides if it's reasonable or not, and if it's reasonable, the government wins. Even if the judge thinks that your interpretation of the statute is also reasonable, and in fact that your interpretation of the statute is better than the government's interpretation of the statute, you would still lose in that case. Well, Philip Hamburger took a look at that and said, well, that's wrong. Clearly that's not the way this is supposed to happen. He wrote a little article called Chevron Bias in the George Washington University Law Review in 2016. And he said, wait a minute, this seems like a violation of due process. You're guaranteed under the Fifth Amendment that you won't be deprived of life, liberty, or property without due process of law. How is it due process if the government is coming after you in one of these administrative proceedings or in federal court? I guess actually, if we're talking about Chevron, we're in front of real judges, Article 3 judges. But how is it due process if you have the better interpretation of the law and you still lose? How is it due process if the judge is pre-committed to favoring the legal interpretation of your opponent in the lawsuit? That just sort of boggles the mind, right? So I know that the term administrative law, sometimes people's eyes glaze over, but this is actually cutting-edge constitutional law is what we're talking about here. We're talking about changing one of the most important precedents from a citation standpoint that affects the most cases every year. It's involved in just about every case where a federal agency is suing someone or being sued. And it's because of this new insight that, wait a minute, there's a problem with judicial independence under the way that Chevron is being done now. There's a problem with bias. There's a problem with due process of law. These are constitutional principles that are important and that mean that what we've been doing under the Chevron doctrine is flawed and wrong and needs to change. So we'll come back to that, but let's go back to the beginning. Where did Chevron come from? Why did we get to where we are? How did this happen? Where did we go wrong? How did this 40-year detour start? So if you go back to the sort of the battle days of the 1970s, originalism hadn't really happened yet. That's the theory that you should look at the original public meaning of the Constitution in order to interpret it. That movement didn't really start until the early 80s. One of the biggest developments there was Ed Meese's speech to the American Bar Association, 85, 86, somewhere along in there. Textualism hadn't really happened yet, right? That came along also in the 80s. Justice Scalia was a huge figure in the movement to sort of get everybody thinking about the text instead of legislative history. Legislative history was king in the 70s. That's what legislative history, purpose, all those sorts of things, and particularly the judges at the U.S. Court of Appeals for the D.C. Circuit, which is one level below the Supreme Court. And unlike the regional circuits, like Kansas is in the 10th Circuit, Missouri's in the 8th Circuit, those are regional courts of appeals. The D.C. Circuit is on the same level as those, but rather than having regional responsibility, it does have regional responsibility over D.C., but mostly what it handles are these federal administrative agency cases. Not always exclusively, but the vast majority of the time, that's where those cases are. And the judges of the D.C. Circuit were going kind of nuts. They were asserting a lot of power, being what you would consider judicial activists, right? They were making the policy decisions themselves rather than following the will of Congress or the executive branch. And the Reagan Justice Department had the idea, wait a minute, shouldn't these judges really be deferring to the executive branch's interpretation of these things? And so they put forward this idea as a way of trying to push back against judicial activism. And whether or not you think it's a good idea, that was from a, I don't think they had fully thought through the constitutional implications of what they were doing. They were just looking at judicial activism is definitely bad for similar kinds of reasons, right? You're not looking at the will of Congress there. You're substituting the will of the judiciary instead of the will of Congress, so you don't want to do that. But the case came up to the U.S. Supreme Court. Actually, at the D.C. It came up through the D.C. Circuit. The decision at the D.C. Circuit was written by Ruth Bader Ginsburg, I believe, if I remember correctly. And the case, though, was known at that point in time by a different name. The head of the Environmental Protection Agency was Ann Gorsuch. If that name sounds familiar, it's because Ann Gorsuch was Neil Gorsuch's mom. And she was the head of the EPA under President Reagan. And the EPA was seeking deference. And I'll quickly tell you what the facts were of the Chevron case, but they don't really matter so much for our purposes. But just to give you a little more of the history, the Clean Air Act had a provision in it that under which the EPA could regulate what are called stationary sources. And the question was just, what the EPA wanted to do under the Reagan administration is they wanted to say, you need to stay in compliance with the Clean Air Act for the plant or the sort of the entirety of the area that your plant is occupying, right? Whether it's a power plant or what have you, so that if one smokestack is emitting more pollution but another one's emitting less, that's okay as long as overall you're in compliance with the law. And the environmental groups didn't like that. They said, no, every single smokestack has to be in compliance with the Clean Air Act, which would be a much more expensive solution. It would also reduce pollution more. So that was the source of the conflict, as sort of, did Congress give the EPA the latitude to take that position, and frankly the states as well, because the states were the ones that were enforcing part of this. Did they have the latitude to treat a stationary source on a plant-wide basis rather than a smokestack by smokestack basis? And because of Chevron deference, they decided that yes, there was the latitude to do that. Interestingly, you won't be surprised that, I mean, you may notice that the NRDC was on the other side of the Chevron case. That's the environmental group, right? Natural Resources Defense Council. So you would think, well, the environmentalists were really anti-Chevron at that time, so they must be anti-Chevron today, right? No, they're very pro-Chevron today. The sides have completely flipped over the past 40 years, and the folks who are pro-regulation are now very much pro-Chevron deference because they think it leads to more regulation, and if you're pro-regulation, then you tend to be pro-Chevron. So that was how it started. It was, someone was talking with me before this started and said, well, you know, they were around in 1984 and they didn't remember this big landmark decision, you know, being handed down. And sometimes Chevron is called the accidental landmark because the court didn't think that they were creating something this significant at the time. This wasn't Brown v. Board of Education. This wasn't Roe v. Wade. This was a case about the Clean Air Act. You know, they didn't think this was that big a deal. In fact, did you know only 6 justices sat to hear the case? There were 3 justices recused from the case. Well, actually, I say recused. I think that, if I remember right, what happened is that 2 justices were sick at oral argument. I think it was Thurgood Marshall and William Rehnquist, who was not Chief Justice yet. He was just an Associate Justice. They were both sick, so they weren't there for the oral argument. And we know some of this because Sandra Day O'Connor's papers are now public. And there was an article by Joan Biskupich at CNN.com just this past week talking about this aspect of Sandra Day O'Connor's papers that she had gone to look at. So there were originally 7 judges who sat, and there was a tentative 4-3 decision in the same direction that it ultimately came out. And then after oral argument, but before the decision came out, Sandra Day O'Connor's dad died, and she inherited some Chevron stock from her dad, and she said, "Oh, well, I gotta recuse now, so I can't sit on the case." So then they were down to 6 justices deciding this case. And if you want to sort of get the blow by blow, you can read the CNN.com article. But long story short, Justice Stevens wrote the decision, and the other justices decided that they were fine with it. But no one thought that this was. No one wrote a dissent. No one was exercised enough to do that. They didn't think that this was that big a deal. But in the hands of, again, primarily Justice Scalia in the 1980s, who was very eager to push back on the activists at the D.C. Circuit, Chevron really grew and became more and more of a weapon to encourage deferring to the administrative agencies. In this case, it would be the Reagan and Bush administration federal agencies as opposed to the judges at the D.C. Circuit. So you can understand why over time maybe some of the environmental groups and whatnot became less keen about, well, I'm sorry, they started off being, not being in favor of it, but then as the Clinton and Obama administrations were getting that deference over time, the environmental groups and other pro-regulatory folks saw the virtues of Chevron, and if you wanted to be cynical about it, you could say that that's what determines people's view on Chevron. Is it sort of whose guy is getting the deference? Is my guy in power? Well, then maybe it's good. If my guy's not in power, maybe it's bad. One of the problems with this Chevron deference is it's not just limited to that context. So Chevron is deference to administrative agencies' interpretation of a federal statute. But there's lots of other kind of deference as well. Has anybody heard of Auer deference? A-U-E-R. Or Kaiser deference, K-I-S-O-R. So that's deference to an administrative agency's interpretation of its own regulations. There's also City of Arlington deference, case from 2013. This is deference to an administrative agency's interpretation of the scope of its own jurisdiction. That's a really bad idea, but you won't be surprised to know that agencies always think something's in their jurisdiction. They're very aggressive about that, about asserting their jurisdiction. And then there was a case in 2005 called Brand X, and Brand X is maybe the furthest that deference has gone, because what Brand X deference says is that if a federal court has already looked at a statute and has interpreted that statute to have a particular meaning, but that the agency disagrees with that, and the agency goes back and writes a new rule disagreeing with the court's interpretation of the statute, and then that issue comes in front of the court again, that the court has to defer to the agency's interpretation of the statute and not its own prior precedent. That's nuts. I mean, that just messes with all of the sort of expectations that we have of precedent, that courts are going to, that these precedents are going to be fixed in the law, right? That there's going to be stability, that's the point of having the courts look at this and fix the meaning of the law. But if an agency can come in after the fact and change the meaning of the law that the court has already decided, and remember, Congress hasn't acted here. The words of the statute haven't changed. It's the same law. But the Republican agency will come in and say, well, we interpret it this way, and the court has to say, okay. And then a Democrat agency comes in and says, nope, we interpret it this way, and the court has to say, okay. And then the other party comes back in and reinterprets it the other way. You can see how it's a recipe for real instability in the law. That's what Chevron has given us, is that recipe for instability. It's also created a situation where the stakes are extremely high in presidential contests, because now whoever the winner is in the presidential election gets to change the meaning of all of those laws unilaterally. Well, that's not what the Constitution says. That's not how law is supposed to be made. But that's what's happening right now. And so that's why the stakes of this are so high, and that's why Chevron, that's another reason why Chevron needs to go. And I think that was an argument, we argued well, I'll get to that, but we argued these two cases in January, Relentless and Loper. And those are the cases that the court will be deciding between now and the end of June and deciding whether or not to overturn Chevron deference. Opposition built slowly to Chevron deference over time. I mentioned the academic work of Philip Hamburger and his views on due process and judicial independence. I think that was definitely a factor. The lower courts started to object to sort of being put in this position, right? If you're a federal judge, you take an oath to the Constitution, and that includes the due process clause, right? It includes, you also, there's a judicial code of ethics that requires you to treat both sides equally, and you're really not doing that under Chevron. Chevron's putting these judges in a bind, and so some of the lower court judges started to squeal and say, hey, I don't like what Chevron is sort of making me do here. This doesn't feel like the right sort of judicial role for us to be put in. The most famous person pushing back on that was Neil Gorsuch, who had a case on the 10th Circuit Court of Appeals, and Gutierrez Brizuela is the name of the case if you want to look it up or read it. But Justice Gorsuch wrote a concurrence to his own opinion in that case, which doesn't happen very often, but I would suggest to you that when a judge writes a concurrence to his own opinion, you should read that because it's going to be interesting. They put the really juicy stuff in the concurrence to their own opinion, because usually that means that they couldn't put it in the regular opinion because somebody else didn't agree with it, right? But it's something they feel very strongly about, so they still want to have it out there. And Justice Gorsuch laid out his view of the problems with Chevron deference, and a lot of what he talked about were how it was interrupting the separation of powers, right? It was favoring the executive branch over Congress. It was putting the judiciary in a position of having to defer to the executive branch rather than behaving as judges, and rather than really fulfilling the will of Congress, it was having to fulfill the will of the executive, and that's not really the way that the system is set up. And so he had these concerns. I guess I didn't mention that the Brand X decision in 2005 was written by Justice Thomas. And the reason that matters is because there's been pushback by litigation as well. And so, for example, the new Civil Liberties Alliance had a case, I guess about 5 years ago now, called Baldwin. And the Baldwin case was interesting. Anybody see the movie Ray? About the life, it's a biopic, Ray Charles. It was starred, I'm blanking on the actor's name, Jamie Foxx, thank you, won the best actor Oscar for that movie. It's a good movie. So our clients were the producers of that movie, the Baldwins, and they had lost a bunch of money producing a movie, not that one, producing a different movie, and so they had claimed these losses on their tax return, and the IRS said that they never got the tax return, and this was a problem. This wasn't like my tax return where that wouldn't matter so much. This was, this was a hefty tax return. They were expecting, I think it was like $160,000 or something like that back from the IRS, and the IRS said they didn't get it. Well, fortunately, there's something called the common law mailbox rule, and under the common law mailbox rule, if you can prove that you put your tax return in the mail, then there's this assumption that what the rule is this assumption that the IRS got it. Right, so they went to trial in federal district court. They put on the stand the clerk or secretary who had put the envelope in the mail and swore, yes, the accountants swore that they had filled them out, and there was swearing that it had been taken to the post office, and the federal district court judge found all of those folks credible and said, yes, IRS, you lose. We're going to assume that this was properly submitted, and so you need to process the return. So, and there was a prior precedent of the Ninth Circuit in a case called Anderson from decades ago that had said that the common law mailbox rule was the relevant rule in California and throughout the Ninth Circuit. Well, the IRS didn't like that result, and so they appealed it up to the Ninth Circuit, and they they had written a regulation essentially doing away with the common law mailbox rule. And even though the Baldwin's return was filed at a point in time before that rule was written, the Ninth Circuit, under Brand X, followed the new regulation anyway and said that the IRS prevailed because of the regulation it had written overturning the Ninth Circuit's view of the common law. Now, I don't have time to explain sort of why, exactly why I think that's as horrid as it is, but I'll just say this. If Congress wants to overturn the common law, it has to pass a statute. It has to get the House and the Senate to agree on a law, and the president has to sign it. Otherwise, the common law is still there and still good. Apparently, the IRS only has to pass a regulation. That seems like a huge problem, that you're giving that much power to administrative agencies when even Congress can't overturn the common law on its own. But in any event, that was based on that Brand X precedent. That's what the Ninth Circuit decided, and so we took it up to the Supreme Court, and we said enough is enough. This is not good for the system. This is a problem. We laid out all the concerns that I was talking about before with Chevron deference apply even more so with Brand X deference. And the court said, no, cert denied, we're not taking it. But there was a dissent from the denial of cert by none other than Justice Thomas, the author of Brand X. And he repudiated his previous decision in Brand X and said, I was wrong. This is wrong. We can't be doing this. He said this is taking us to the brink of administrative absolutism, and we need to take a step back. And so we were thrilled. I mean, we would have been more thrilled if there'd been cert granted and we'd been able to get the Ninth Circuit's terrible decision overturned on behalf of our clients. But the fact that Justice Thomas, of all people, the author of Brand X, was willing to say, this is wrong and we need to not do this anymore, that was sort of a crack in the foundation of these deference doctrines, right? So that was a pretty big deal. And then something else that happened that I think is you might not be obvious why this matters, but the Dobbs decision came down overturning Roe v. Wade. And one of the things that I think had been happening no one has said this, there aren't decisions saying this, I'm not even sure there's a law review article out there saying this, but there's an understanding in the appellate bar that one of the reasons that folks were so adamant to not overturn Chevron was that if you overturned a decision from 1984, that might make it easier to overturn a decision from 1973. And the people who liked Roe v. Wade did not want to overturn Chevron because they didn't want to make it easier to overturn Roe v. Wade. Well, Dobbs took care of that. Like it or not, it overturned Roe v. Wade. So that issue left the stage, and that allowed you to take a look at Chevron deference on its own without that sort of overhang of what it might mean for other kinds of decisions. And so we have these two cases before us this term, Relentless and Loper, that have teed this issue up. And the underlying statute in both of these cases is the same. And by the way, Loper is the name of a boat, and Relentless is the name of a boat. These are fishing boats in the North Atlantic, and they fish for herring. And our clients have the Relentless and the Persistence. Those are their two boats, and actually their third boat that they just bought is the Prevail. So hopefully that's meaningful. We'll find out at the between now and the end of June. And they fish out of Kingston, Rhode Island. I believe that the Loper folks fish out of Cape May, New Jersey. But the National Oceanic and Atmospheric Administration, NOAA, has a sub-agency called the National Marine Fisheries Service, and part of what they do is keep track of fish stocks, right? Sort of make sure things aren't overfished. And for a long time, at least a few decades, they've been putting monitors on boats that go out and fish in the North Atlantic. Not every boat, but they have the right to put a monitor on your boat when you leave the dock. And there's all sorts. I mean, these are very detailed regulations. If you're out for a certain number of days, then you're more likely to have a monitor. If you're going out and back the same day, then you can do an inspection at the dock instead, and there's all these sort of details about it. But whether you like that policy or not, no one had really been fighting it or had been concerned about it because the government was paying for those monitors' salaries. Well, Congress decided to stop paying for those monitors or pay less or just reduce the agency's budget to the point where they weren't able to pay for the monitors. And so the agency decided, well, we're just going to make the boats pay for the monitors. We'll just charge the boats. And you might say, okay, well, that's fine. I mean, makes some amount of sort of policy sense that you might charge the boats for that. Well, the problem is that the charge is about $700 a day, which is more than the amount of money that the boats make from fishing. So if you draw the short straw and you get a monitor, you're guaranteed to lose money that day. That's kind of a bad. It's not a great situation to be in from the standpoint of a regulated party. And so the fishermen said, that, you know, we're upset. We're going to sue. We're going to fight this. And in particular, they said that the statute doesn't give the agency the power to force them to pay for this. There are two specific provisions of the statute that allow for charging the boat owner for monitors. One of those is if it's a foreign vessel. If it's a foreign vessel fishing in U.S. waters, we can put a monitor on there and we can make that foreign vessel pay for the monitor. Congress said that. Everybody agrees with that. No one disagrees. The second instance that they can do that. Do I remember what the second instance is? Oh, I know. It's in the North Pacific. Well, the North Pacific has very high dollar sort of fishing going on, like Alaskan king crab and things like that, right? Much higher margin fish. Herring is not a high margin fish. It is a very low margin fish. And just because Congress said that you can do something in North Pacific does not mean you can do it in the North Atlantic. But what the agency said is, it's ambiguous. There's a gap in the statute. And you, court, have to defer to us. And we say that the North Atlantic also is someplace where you can force people to pay for these. And so that's the particular underlying issue. That's the statutory issue. And our clients feel like, well, they went to district court and they made their case, and the district court said, Chevron deference, you lose. And then they went up to the First Circuit Court of Appeals, and the First Circuit Court of Appeals said, you make a good point, but Chevron deference, you lose. And so they really feel like the U.S. Supreme Court was the first time that anybody has heard their case where they weren't just predestined to lose because of this Chevron deference doctrine. And I was there on the steps of the Supreme Court with our client representative, Megan Lapp. And by the way, Megan's great, and there's a video on our website, nclalegal.org, where you can go and watch this about a 5-minute video of Megan and some of the other folks from Relentless, talking about the case and talking about the fishing and everything. And Megan has this wonderful kind of northeastern accent. And whenever she says, "an at sea monitor," it sounds for all the world like she's saying a Nazi monitor. And it's just a function of her accent, but it cracks me up every time I hear it. And it might amuse you too if you watch the video. So there's a couple interesting things about the Relentless and Loper Bright cases. I said it's the same statute, but the court granted Loper Bright first, granted it last summer, I think maybe in July, and then they granted Relentless in October. And you might say, well, why would they grant both of these cases? I mean, it's the same case. They could just grant one and hold the other one. They don't have to have both cases orally argued, like what's going on there. And I mean, the short answer is, who knows? I mean, you don't really know. Someday when somebody else's notes are available after they die, then maybe we'll get the full story. But the insiders, the sort of Supreme Court bar, thinks that what's going on here is that Justice Jackson was originally assigned to the Loper Bright case at the D.C. Circuit. And even though she had been elevated to the Supreme Court before the decision came out in that case, it might be a kind of an automatic situation that you're recused from the case. And in fact, she heard oral argument in the Relentless case. She did not hear oral argument in the Loper case. So that could very well be the reason why they granted the second case. They maybe didn't want to attack or they didn't want to take on an issue this big with only 8 justices, because maybe they'd split 4 to 4 or something like that, right? So they wanted to have the full complement of justices available, and so they granted Relentless as well, so that they could be sure to have a vote. And that already happened before, right? In Chevron itself, you started off with 9 justices and you ended up with 6. So maybe they were thinking about that too. They had reason to be concerned. But the other thing that was interesting about this case is that both in the Loper-Bright cert petition and in the Relentless cert petition, we posed 2 cert questions for the court. One of them was sort of a statutory interpretation question, like, are we right about the interpretation of the statute? And the second question that we asked the court was, would you overturn Chevron? And the court only granted the second question. It didn't grant the first question. So that was interesting, because the court has looked at it. Other people have tried to get the court to look at this Chevron question over the last several years, and the court keeps saying in every case, well, we don't need to reach the Chevron question because the statute is clear. And they've said that in 4 or 5 different cases where people have tried to get them to look at the Chevron question. And so they can't say that this time, even though I kind of think the statute's clear. But they didn't grant that question. So they're definitely going to decide the Chevron piece of it this time around. Just a couple more thoughts, and then I'll open it up to any questions that you guys have. So there was this big concern back when Chevron went in about judicial activism and judicial policy making. So why are we not concerned about that now? Why are we not, like, now, if Chevron goes away, are we going to invite more judicial policy making and judicial activism? Are we just going to go back to the bad old days of the 1970s? Why are we not worried about that? Well, I think one of the main reasons that we're not worried about that is because of the advent of textualism. And Justice Kagan famously said a few years ago, we're all textualists now. And even though there are still lots of disagreements between the various justices based on their ideological positions, they really do, from not just at the Supreme Court but lower courts as well, from a methodology standpoint, text really is something that all the judges pay attention to much more than they did back in the 1970s. And so I think that there's reason to believe that textualist judges will really do the work of judging, that they'll really look at the statutes, they'll decide what Congress intended, and they'll come up with their best understanding of what, not what Congress intended, but what Congress wrote, right? The only way that you can look at the intent is the actual language that passed through both houses and signed by the president. Whatever intents that they might have that aren't expressed in the text, we don't have access to those. We don't know what those are, so those aren't law. And so I think that that concern is certainly lessened. But the other thing that has been happening, and Kevin said that this is something you guys have talked about, at least in one of your classes, the major questions doctrine, is sort of something that has come about as a response to Chevron and some of the problems with Chevron. And the court hasn't wanted to use it. And in fact, even though the lower courts are still citing Chevron every day, the Supreme Court hasn't cited Chevron in a way that affects the decision in a case for about 7 or 8 years. It's really been avoiding Chevron like the plague, which also I think gives you a hint as to where we're going in terms of overturning it. So what have they been doing instead? Well, they've come up with this major questions doctrine. And we can talk more about that, but what I would say about the major questions doctrine is that it's I think it's in part a response to egregious overreaches by the administrative state. So you have, for example, the CDC claiming the ability to implement a nationwide eviction moratorium. Well, the CDC isn't even it's not the agency that oversees housing. And Congress certainly didn't ever give the CDC the ability to do that. And yet, if you look at the lower court cases, I mean, the CDC, we sued the CDC over the nationwide eviction moratorium, and the CDC won in the Northern District of Georgia, and they won at the 11th Circuit, and we were on our way to the Supreme Court, but another case got there first, Alabama Realtors. And when the Supreme Court looked at it, they said, if Congress meant to give the ability to the CDC to do a nationwide eviction moratorium, we would expect it to use clear language to give them that kind of power. We're not going to read that into an ambiguity or a gap in the statute, right? So that's major questions doctrine. It's almost a substitute for Chevron, for a Chevron framework. And they used it there. They've used it in the OSHA employer vaccine mandate case. They used it in the student loan cancellation case, Biden v. Nebraska, right? So the Supreme Court's been using it a lot. I think it likes the major questions doctrine. And it's much easier than the Chevron doctrine to understand. Essentially, if the problem's big enough, then we really, Congress, the saying that Justice Scalia had was that Congress does not hide elephants in mouse holes. And a lot of times what the administrative agency is asking the court to believe is that Congress was hiding an elephant in a mouse hole, sometimes a woolly mammoth in a mouse hole. I mean, these are the kinds of things that they try to claim that they have the authority to do based on the scantest of language, or they say there's a gap in the statute. No, it's not a gap in the statute. Congress just didn't legislate that. They just didn't. The law just stopped, right? They didn't make a decision on that, but that doesn't give the agency power. Final thought. So what happens if Chevron is overturned? Does that mean that all these federal agencies are not going to be able to regulate anymore? That they're never going to win in court? No, it doesn't mean that. I mean, that's what the sort of pro-Chevron forces are putting out, this parade of horribles. But I'd like to point to a couple things. First of all, the state of California at the state level does not have a Chevron deference doctrine. And you may have noticed that the agencies in California don't have a problem regulating. They regulate a lot. So I don't think Chevron's a magic bullet that's going to make these agencies stop regulating or be unable to regulate. I do think it's going to stop some of this overreach that we've seen, some of this really lawless off-road driving when it comes to these huge power grabs. I do think it'll stop that. But I also think that the agencies are going to push back, and we don't know exactly what that's going to look like, but if Chevron gets overturned between now and the end of June, they're not just going to roll over. They're not going to say, well, that was fun for 40 years. It was good while it lasted. They're going to continue to try to find other ways of tilting the playing field in their favor. And whether that's with fact deference doctrines that we're also attacking, but we haven't made as much progress there, whether they're going to say that these are questions of fact and not law, and yes, the courts get to decide the law, but we still get to decide the factual questions and the administrative record and all of this, and there'll be some debates and some fights of that sort. And I'm sure there'll be other things that they do, and we'll just have to, it's not a one and done sort of case. So it's a very important step. I think that overturning Chevron is huge. I think it's very beneficial for individual liberty. If you sue an agency or get sued by an agency, you'll have a fighting chance now, which honestly you didn't before. We see win rates. When Chevron is invoked, we see win rates for the agencies of 80–90%. And in cases where Chevron doesn't apply or isn't invoked, agencies still win probably 55–60% of the time. But that's a big delta. So you have a fighting chance. So maybe I'll leave it there and see if there are questions. I'm happy to take this in a lot of different directions or answer questions you have about how other aspects of this work. But let me leave it there.
at the beginning you mentioned executive orders in relation to the Chevron deference. I was just curious, have those two things been used in the same context? Like, have there been cases where it's not about Congress giving power to like the CDC or something? Have there been cases where the president does something and a court says, because this was what we deem reasonable, they quote Chevron, and it's okay? Like, has that happened before?
For kind of orders, even the abusive ones are supposed to operate in the following fashion. It's the president telling somebody else in the executive branch what to do about something, right? So it's not the president directly regulating you. It's supposed to just be kind of an intra-executive branch order. That's what an executive order is supposed to be. It's very hard to sue the president, believe it or not, on these administrative sorts of things, because typically the president isn't the one who's doing the thing that you need the government to stop doing to you. So typically the president gets knocked out of these cases. We have a case pending right now at the Supreme Court called Murphy v. Missouri. It was Missouri v. Biden when it was filed. But even though the Western District of Louisiana and the Fifth Circuit sided with us, even they said, well, President Biden gets out of this. Like, you can't sue him. So so for that reason, no, it hasn't. Well, yes and no, because where did the nationwide eviction moratorium come from? That came from the White House. I mean, functionally, it was CDC, but that was really the White House. So originally, if you guys remember, there was the CARES Act, right? That was there was a in that original law that was passed when it was at the end of March, I think, of 2020, or maybe early April of 2020. There was a provision in there that that had a 6-month moratorium on evictions in federally subsidized housing. That's it. Congress passed that. The president signed it. It expired after 6 months. Congress never extended that. And not only did the agency extend the moratorium, but they went outside of federally subsidized housing and said no landlords anywhere can evict any tenants, which that was never something that Congress went along with. So, and then obviously at the end of the Trump administration, the Biden administration did the same thing and kept extending the eviction moratorium. So that was one where both executives were guilty of the same thing, but the case that made it up was against the CDC. So does that make sense? Okay.
So with the Nebraska student loan case that you brought up with major questions, correct me if I'm wrong, but there seemed to be a disagreement over how the court should use major questions in that case. So how do you think that disagreement will play out in these Chevron cases now, and how do you think it'll affect like what the court will do going forward if they do get rid of Chevron?
There appear to be a couple of different versions or views of what the major questions doctrine is, or how the major questions doctrine works. And we did see it play out a little bit in the Nebraska or Biden v. Nebraska case. If you go to the Federalist Society's website and you look for the courthouse steps talk that was done after oral argument in that case, you can hear me for 45 minutes on this topic. But let me give you the 45-second version. I think that the one version of the major questions doctrine is as a clear statement principle, essentially just saying we're not going to interpret the Congress to have given something unless there's clear language. Justice Kavanaugh seems to think that there's a kind of a flip side to that as long as there is clear language, then there is no major questions doctrine. And I'm not really sure where he gets that from, because the Constitution doesn't say that the separation of powers only applies when there are major questions at stake. The separation of powers applies all the time. But he seems really quite willing to go along with the agencies on things that are not major questions. I find that wrong and dispiriting, and hopefully I'm misinterpreting him and it won't play out that way, but I'm waiting to see that as well. So we'll see.
So thank you very much. My question actually was because you talked a little bit about like if Chevron is overturned, but my question is sort of if Chevron is overturned, what would be the relationship between the judiciary and the federal agency, or like just the like federal agencies afterwards?
Well, it'll be the same as it is now. So one of the things that argument was that sometimes a case makes it to federal court before the agency has spoken on its interpretation of a statute. And if an agency under Chevron, if an agency has issued a regulation or formally kind of weighed in on its interpretation of a statute, that's where Chevron deference comes into play. But if you sue the agency, say first, or somehow this issue crops up before the agency has had a formal position on it, then the agency might take a position about the meaning of the statute in its briefs to the court, sort of a litigating position, but they don't get deference on something that's a mere litigating position. And so one of the points that Roman Martinez made on our behalf at oral argument was that the courts already do this in cases where the agency hasn't weighed in yet. In other words, they already have to interpret the statute without the benefit of Chevron deference in some contexts. In fact, I referred to the Administrative Procedure Act. I think it's Section 706 of the APA is the one that talks about de novo review. And one of the sort of going back to the accidental landmark point about Chevron, one of the things that's interesting about the Chevron case is that the APA doesn't apply to the Clean Air Act. And that's as a matter of statute. You just go to the Clean Air Act, and there's something called the mini APA. Like within the Clean Air Act itself, there's some procedural things that Congress set up, but it exempted the Clean Air Act from the Administrative Procedure Act. So people say, well, how could they have decided Chevron back in 1984 and never even noticed that the Administrative Procedure Act requires de novo review? Well, it doesn't for the Clean Air Act. So that's another aspect in which it just sometimes these cases will come up in ways that particular statutes won't apply to them, or to the point of what if? So for example, if the case if Relentless and Loper are decided in a way that says, suppose they don't reach the constitutional question, suppose they don't weigh in on this judicial independence point or the due process point or the bias point that I was making. Suppose they just decided on APA Section 706 grounds, and they say the statute says, or Congress says, that it's de novo review. Chevron is wrong to contradict that, and therefore we're overturning Chevron on this sort of statutory basis, this 706 ground. Well, that would only apply to cases that the Administrative Procedure Act applies to. And there are agency cases like the Clean Air Act that the APA doesn't apply to. So one of the things we told the justices was, please don't just decide this on 706 grounds, because then there's going to be a question in the lower courts as to does Chevron still apply in some rump group of cases, and we don't want to see that happen. So hopefully they'll have a little bit of a broader decision. Does that answer your question? Yeah.
The action was upheld at Chevron Step 2. Mass challenges, mass revisiting of the authority to have promulgated the rule, nothing like that.
So that exact question was asked at oral argument. And the transcripts, I mean, if you have time to listen to the oral argument, I think that's a fun thing to do. If you don't have time to listen to the oral argument, you can read one of these transcripts pretty quickly. I mean, that oral argument's 2.5 hours, but you can read through the transcript probably in 20 minutes. It's not that long. So if you're interested in sort of seeing the kinds of questions that the justices were asking, you can do that. But that exact question came up from Justice, I think Justice Jackson, Kagan, Sotomayor. They all had those sorts of concerns about what's going to happen. And the answer that we supplied was that there's still statutory stare decisis. And stare decisis is the judicial doctrine that once a case is decided, and this goes back to why Brand X is a problem, because it upsets stare decisis. But once a case is decided, that rule applies to that case, right? It's decided, it's settled at that point. And it's not that you can never overturn it, whether it's statutory or there's also constitutional stare decisis, right? So you're supposed to be reluctant to overturn a case. There should be sort of special reasons to overturn something. And what we said was all those same stare decisis factors will apply. And so it's not that someone couldn't challenge the previous law, but they're going to have to overcome all these stare decisis factors in order to do so. Now, I think myself that there's probably some subset of cases out there where they were decided based on Chevron, and they were decided based solely on Chevron sort of step 2, just the reasonableness. And there's some subset of those where the court probably said, we think the litigant has a better interpretation than the government, but the government wins anyway because of Chevron. That subset of cases, I do think, is potentially able to be relitigated. But you're still going to have to show some of the factors that courts look at on stare decisis is how important is it, how settled is it, are there expectations that have been created, so again, reliance interests, exactly. And so you have to look at all those sort of things to overturn. So I don't think it'll be set of regulations that are out there that have been litigated are suddenly wide open for relitigation. Which was argued several weeks after case in its own right. Under the APA, agency promulgates a regulation, and that done away with Chevron, then aren't we really opening the floodgates to all this litigation? And a lot of people are reading into that. That as a good sign.
Coming. Article to with Chevron and Brand X
to the colonial times or to the royal prerogative in the sense that it didn't operate that way at all. You know, it was just that the king had his own courts and appointed the judges and could hire and fire the judges. And you know, if you it took the judiciary in England a long time to achieve independence from the crown. For a long time, if the judges ruled against the crown got rid of the judges, and you know that might have influenced some decisions along the way that judges were making too, if they didn't want to get if they didn't want to lose their judgeship. So, but I don't know that there would be a real analog to this sort of Chevron two-step process from colonial times. I'll ask Philip that question though. See if he thinks that there might be something. He's the legal historian. I'm more of a litigator.
I guess, would you be okay with possibly like Chevron-esque deference on the state level? Because I guess state judges operate a little bit differently, because in this case they would have to determine whether something is like consistent with the text rather than just agreeing with a proposal. So would you like think that such a Chevron-esque deference, even if Chevron eventually is overturned, would be permissible, or if you would agree with it?
Well, so we have 50 different state constitutions, and it could be that there are that the statute, that the separation of powers is handled differently at the state level in some of the different states. So it could be that the constitutional problems aren't there strictly from a looking at the state constitution standpoint. I suspect that in most states that it would still be a problem from a state constitutional standpoint, and I think that the sort of due process and judicial independence problems I talked about would be true regardless of what the state constitution says, which isn't to say that you would have a federal constitutional claim against state Chevron, state forms of Chevron. But you raise a good point. So there are, and I should have said this before in terms of the opposition to Chevron. It's never been the case that 50 states had Chevron doctrines. So I mentioned California doesn't, New York doesn't, Florida doesn't. It was about 50-50 for a while. I think it's more like about 35-ish states don't have Chevron deference. So one of the things that's been happening behind this, well, not really behind the scenes, one of the things that's been happening that has put pressure on the Supreme Court to reverse Chevron is that a bunch of states have been reversing it. So Arizona passed a statute doing away with state level deference in Arizona. Wisconsin had a state Supreme Court decision that did away with deference in Wisconsin. Florida adopted an amendment to the state constitution to do away with deference to administrative agencies. Ohio, Mississippi, Arkansas, Georgia. There's just been Michigan, over the last 10 or 15 years, there's been a flood of states that have gone the other way. They've all been going in the anti-Chevron direction. I think the only state that I know of that has explicitly, and it's not that they were the other way and flipped, they just put out a new decision. Massachusetts did, saying we have this deference policy in place and we like it and we're keeping it. So that's one state that's on the other side. But no, I wouldn't be okay with state level kind of deference. I mean, there may be a little bit less of a concern with the amount of power that the state has compared to the federal agencies. But I would still, if I were the one that was trying to sue that agency or being sued by that agency, I'd want to be in front of a judge that didn't have to defer to the legal opinions of my opponent, for sure. Really.
I think so. All right. Thank you very much, Mark.
And I did bring some NCLA stickers if anybody is interested in a sticker, and some fun sort of founding fathers coasters that folks are welcome to grab one of those if they want as well. Kevin, I brought you a deference doll.
Thank you. That's great.
So if you push it up from the bottom, it will bow. Also brought you a copy of the actual briefs from the case.